So good morning. Welcome to the third Business Development Club of 2022. If you don't already know me, I am Paddy Woods. I'm Director of Pimento Fuse and Head up the Marketing New Business of Pimento. If you haven't been on previous calls, please use the chat box to ask questions. And we want to make this session as interactive as possible. So please do ask questions and I'll be bringing you into the conversation as we move forward. Today's session is going to be recorded, as you saw when you signed in, and we'll be sharing the video on YouTube later today or tomorrow. So today's session is all about protecting your IP in new business. It's an issue that's been around since the dawn of time, and it's again raising its head in many different ways, from clients ghosting to actually clients stealing ideas. There's two I've heard of in the last 2 years or 3 years. First one was the agency Manifest pulled up Brewdog for stealing their ideas, and sort of in a very public way. And the last one happened last month at the Super Bowl when Coinbase CEO stood up and publicly declared that no agency could have created an ad like the one they had. It caused the CEO of the Martin agency to actually publicly voice on Twitter that they had actually produced this and showed them the page references on the deck that they had shared with the client. So to bring this back into the session, I brought in the fantastic Sarah, Molloy and Lindsey, Wrenn, who are from Clarion. They are going to talk about IP in much more detail than I can ever be able to do. So to go through their bio, Sarah is the Senior Associate for the Intellectual Property team at Clarion. She focuses on trademark filings and portfolio management within our intellectual property team. She uses her excellent knowledge of different trademark systems around the world to the benefit of our global brand clients. She advises clients on all aspects of global trademark portfolios, helping them with the registrability of marks, brand clearance, successfully overcoming objections and oppositions, renewals, enforcing trademark rights against third parties and agreements relating to trademarks. She helps by reviewing clients' trademark portfolios on a regular basis and provides detailed recommendations about how best to improve the existing protection for brands and identifies areas for cost savings. Lindsey Wrenn is the partner of the intellectual property team, and she's been in the trademark specialist for over 25 years and has held senior roles within a number of national and international law firms, as well as having worked for a boutique trademark practice and in-house. She's a registered trademark attorney and member of the Chartered Institute of Trademark Attorneys and advises on all aspects of trademark and registered design protection, from brand clearance, filing applications in the UK, Europe and internationally, through to drafting and negotiating licenses and assignments. She also has a wide experience of the enforcement and preservation of trademark and design rights, including filing and defending oppositions, invalidity and revocation actions, and the conduct of hearings. They both work for Clarion, who is a law firm based in Leeds, and Clarion works in partnership with a wide range of businesses across the UK and internationally, helping them have an excellent experience and expertise across the media sector, acting not only for large corporates and independent organisations across both digital and traditional media, but also independent publishers, producers and design houses. They showcase in-depth experience in advising media organisations on an extensive range of commercial issues, providing advice to the sector across the corporate, employment, IP, property and commercial teams. They utilise the breadth and depth of this cross-practice expertise to help clients through the constantly shifting media landscape, providing support, particularly in the field of management buyouts and acquisitions. So Sarah and Lindsey, it is great to have you here. Sorry, it's a long-winded introduction, but it's great to have you here. So thank you for joining us. Today's session, Sarah and Lindsey are going to do a sort of a 20 minutes or so presentation, and then this will be followed by the Q&A. Halfway through the presentation, we're actually got a very, very quick poll around the impact of ghosting and seeing if you guys have been affected by it. So let's get started. Sarah and Lindsey, if you'd like to sort of take the reins and start the presentation. So thank you.
Thank you. I'll just share the screen 1 second. There you go.
Okay. Thanks very much for the intro, Paddy, and good morning to everybody, and thanks for joining. Can I just give you a brief overview of what we're intending to do in the scope of the session? I don't know if you can move the slide. Can we do? Yeah. It's going to be a little bit of a whistle-stop tour of IP. So we're not going to go in the full gamut of telling you everything about IP and every different type of IP right. So what we're going to do is basically focus in on copyright and trademarks, basically because they're the most relevant to your business in terms of creative output. So and hopefully we'll tie them together and help you going forward in order to protect yourself and protect your clients, and also to limit your liability with your contractual relationships with clients and when you engage in pitches. So that's basically an overview of where we're going to go. Just a quick view of the types of IP rights that there are in this particular category. The key rights are identified on the screen. There are others, you may be aware, I'm sure, of patents, trade secrets, and other different types of IP rights, but we're not going to touch on those today. So trademarks, they can be both registered and unregistered. So with the trademarks, we're protecting brands, most often a name or a product or a service. The most common types of trademarks are words or logos. I'm sure most of you are and daily engaged in designing logos for your clients. Trademarks can be protected either by registration or built up over time through use. So if you register a trademark, you get a statutory monopoly. If you don't use your trademark but have used it for many, many years, you could build up rights through the common law in passing off. This is based on reputation and goodwill built up over a period of time, and is protected by law, but it's not just statutory rights, so it's less easy to enforce. But it doesn't cost you anything because it accrues automatically. Designs, again, they can both be registered and unregistered, and this the design right protects the overall visual appearance of a product or part of a product, but it doesn't protect the sort of function of the actual product. So it's only the appearance that is protected. Probably of most importance and interest to you guys will be copyright, and that protects the way in which information or ideas are expressed and essentially protects against copying. Again, it's a right that accrues automatically, and it's not a right that you can actually register, apart from in the States and in China. So I'm now going to pass across to Sarah to dig a little bit deeper into copyright protection.
Thanks, Lindsay. Yes, the few things I want to discuss today, first of all, being the important right of copyright. I think the key thing to get across, especially to this audience, is that you can't just protect an idea. If you have an idea in your head, it's an idea, it's a concept, and it's about how to get that protection of that idea. And what I mean by that is it's putting it down into some kind of written format, artistic works, typographical works, and different types of arrangements. So I'll go through each of those because I think that's a key thing just to get across from the start about what rights are available to you and how to obviously obtain protection for them. As Lindsay just mentioned there, it is an automatic right. It automatically is created. You don't have to register it in the UK or in the EU. It is something that as soon as you, if you like, put text down on paper, then a copyright is attracted from that. Literature works, so we're talking there, and I'll go through some examples. So your text on there, your words, different things, different wording on your packaging. The artistic works, so again, the designs of how the packaging looks, how you've created your logo, the artistic works that you've put into the design of that logo. Typographical arrangements there, the layout of how things look with publications or on your website, particular layout of that. Dramatic works, again, what they're saying on the screen there is different film arrangements or sound recordings. The important thing to take away from this is that it has to be original. There has to be some kind of skill, judgment, and labour. And so how that accrues is making sure you've got that originality first of all with copyright in order to get that automatic protection. And again, as I've just mentioned there, it's not just something that pops into your head and protecting that idea. It's making sure you get through it in different forms. And I'll talk through some of those examples now. I always think it's best to try and visualise something myself. That's how I learn. And looking at this on the BBC website here, So we've got the logo in the corner. So you've got the BBC News logo. So you've got copyright in that. You've got several different photographs on there. Again, copyright exists in all of those. There's various different texts on there with different wording about staff who uncover the post office, etc. You can see that copyright exists in that. And the whole layout of it has its own copyright protection as well. So it looks that way again. So copyright exists in that. There's some diagrams on there as well. And even you can get copyright protection for a headline as well. There was a key case some years ago about making sure that copyright does exist in a newspaper headline, or to make sure that you can't just copy that, should we say. It's important to be aware of that. So some further examples here. It's quite an extensive list, so I apologise for that, but I'm just trying to think of different things which would be relevant for you guys. Again, I've already mentioned there, text and logos is obvious really where copyright may exist. But something again that people may not originally think about is such as your social media posts. You've got copyright in that because obviously it's text and it's posts, it's i.e. in a written communicative form. So articles, again, the headlines as I've just mentioned. Quotes, again, it might just be a simple sentence, but copyright can exist in a 4-letter sentence. It is all about originality, and like I said before, just making sure you've got that skill, judgment and labour in that creation. Videos, animation, again, I think that's an obvious one that copyright would exist in those particular types of rights. But again, they've got packaging, how things look. A lot of people are now obtaining copyright protection and design protection for how packaging looks, especially with supermarkets, various different value supermarkets, budget supermarkets, copying people's packaging. So again, people are going down the right of obtaining design protection and also relying on their copyright works, which automatically arise. You've got apps as well, how a website looks. Sounds, for example, Netflix they've registered as a trademark, which Lindsey will talk further about what trademarks are, but they've registered the sound of, as you turn the TV on, you might hear da-da-dum, and that's the sound again. So there are things that can be protected, and it's about picking out those key things for you as to what is important to register if you wanted to do, and also how to protect that. So that's just a quick snapshot of different types of works where copyright automatically exists. So how long does it last and who owns it? Is obviously the key question we get asked a lot of the time. So it usually lasts, like I say, 70 years after the end of the year in which the author dies, but there is some exceptions for that, especially with the computer generated work, and that the key number there is 50 years. But the point I want to get across to all of you today is the creator is the owner. People think if they pay for it that they automatically own that, and that's not the case. It has to be assigned in writing. I do sound very legal when I say that, but that is under the law. You can't legally transfer ownership of copyright, of trademarks, without it actually being in writing and being signed by the person who has created it, i.e. the assignor. And so in order to effectively transfer title from one party to the other, it does have to be in writing. It doesn't have to be a long detailed agreement. We can just do 1 pages or in a letter, but it has to be expressly in writing and signed by the party that has created it. So I think that's something to think about, especially just jumping ahead there. If, for example, with consultancy agreements, if you use another third party to create some content for you for a pitch that you're doing for another third party, it's important to make sure that if they are a consultant, that the IP would vest automatically in them. If they're not an employee, because if you are an employee, then employee works belongs to the company, unless your employment contract states otherwise. So if you are using any types of consultants, because they're not classed as an employee, then the creation of any content they create vests in themselves. So it's important to make sure you have the right agreements, making sure that chain of title comes back to you in order to have it in your possession. And I think it's always important, I'll come on to this after we've done the poll, but making sure what exactly do your terms and conditions say? Where does the IP sit? Is that something you've done recently? Had a look in your T's and C's if you're using it for pitches or you're using it with your clients, what do they say about ownership of IP? I think it's always important to dust them off and have a look at them now and again to make sure it is where one thinks it is, because sometimes that's not always the case. As we've mentioned there is not a UK register of copyright. There is a UK register for trademarks and for designs and patents, but not for copyright. So you can't check that you're not automatically infringing someone by going and having a look on the UK register to see if somebody's registered something already. There is overseas different jurisdictions which do have registered protection, as Lindsey mentioned, in the US and in Canada and China, but over here that's not available to us. But I think the point is, even if somebody takes a small part of something, whether that be you or whether your client takes something, and you can still infringe. It doesn't have to be the whole text or the whole piece of work that you've done. It could be just a photograph, or it could be, like I say, a few sentences. It's making sure if it's a substantive amount, and there's various different case laws to what is substantive, but it could just, exactly what I mentioned before, just be a headline. That could be seen just to be substantive. So even if you take a small part of that and change it, that's not okay. Don't do that. So I think that's the point I wanted to kind of get across, because there's a few myths as to what you can and cannot do, really. And so it's just making it clear that you can just change a few things around, should one say, and it will be okay. You've always have to just make it clear as to what your inspiration is and where it's come from, because that would always be a key bit of evidence if you were ever challenged on an infringement basis. So I would always recommend is always having what I call a clean room environment, and always keeping a record of the design process. This can be really invaluable, especially with an infringement claim. In the old days, one used to post their works themselves in sealed envelopes, so you knew had a timestamp on it as to when exactly it was created and by whom. I think we've moved on from that nowadays, and instead it's all about data and making sure you have a trail of when your records were created and when your computer records were created. And remember, these records are really important in order to have that timestamp as to when it was created and by whom. Again, if you ever got into some kind of disputes about an infringement action, then the other party would have the possibility to scroll through these. So it's important to make sure you have a clean room, if you like, making sure you file all the data and have a clean design trail as to how it was created in an ideal world. That's a whistle-stop tour really of copyright, and again Lindsey's just going to chat a little bit about trademarks, and then we'll discuss about how you can protect yourselves and the question that Paddy posed at the beginning. So just over to you, Lindsey.
Thank you, Sarah. Yeah, I just thought it'd be useful to say a few words about trademarks just to put in context, and obviously they could be very well, very much of interest to you personally, but also in terms of your conversations with your clients and how you go about thinking about branding and what are the implications of creating new branding for your clients. And if clear, we also strongly recommend you always carry out searches, but the possibilities of protecting those trademarks once they've been created. So the essential premise for trademarks is that they need to be distinctive in order to be protectable. So if a mark is descriptive in any way, then it's unlikely to be accepted for registration. Or if it's a common use and name in the trade, for example, it will be refused. So it has to be unique and distinctive. And it also has to identify origin, which basically means that it allows your clients' customers to identify those goods and services from those of their competitors. So there has to be originating from you and you alone. The good thing about trademarks is they can potentially last forever. You can renew them every 10 years. So and they're really, in terms of the cost effective, it doesn't cost you much to renew or indeed to register. And so there are, it's a perpetual monopoly essentially. One point to note is that trademarks are territorial, so if you have a registration in the UK, then the rights are confined to the UK, so you wouldn't be able to stop anyone from using the same or similar mark in another jurisdiction unless you have protection there. So it's always worth flagging with clients if they have international aspirations that there are other ways and means of protecting trademarks in other countries, either pan-European via the EU IPO, or via what's called the Madrid system, which is an international filing system. It's slightly misleading because you don't get global trademark protection. Sadly, there's a lot of misconceptions about that, but it's essentially a portal where you can acquire a single registration, but in a number of different jurisdictions, and the cost depends on how many countries you include. There's a vast number of countries that are party to the Madrid system, but there are some that are outside the system and you have to file nationally, such as Taiwan and South Africa. But most of the key countries, US, Australia, Canada, China, are all included in the Madrid system. Trademarks are categorised into different goods and services, and you have to categorise them into which class those goods and services fall. It's more of an administrative system, really, in terms of costing for trademarks. So the cost will be dependent on the different numbers of classes of goods and services in which the mark is protected for. And in terms of timescales, at the moment the UK is probably taking about 3 or 4 months from filing through to registration. A little bit longer for the EU, probably more like 4 to 5. And then the USA and China, you're looking more sort of 12 months plus, and in some countries it can be even longer. But the point to bear in mind is once a mark is filed, that's essentially drawing a line in the sand, and the rights to the mark accrue from that date. So if anyone then infringes a trademark registration, once it's registered, that those rights can be backdated from the day of filing. So if anyone comes in between, you can then sue them once your mark is registered. So just to give a few examples of different types of trademarks, the most traditional types are the obviously the plain word marks in text, or sometimes stylized. Word marks give you the strongest monopoly and the strongest form of protection. So if a mark is distinctive and it warrants a word mark application, would strongly recommend that you go down that route. However, sometimes marks are less distinctive and might be on the borderline, and they can easily be also protected as a logo, either alongside a device or in some kind of stylized form. Those are considered more the sort of traditional trademarks, the word and script and logo trademarks. There are other, what they call non-traditional trademarks, which are becoming more common, but a little bit more difficult to protect because they're slightly different. But you can register a shape mark as long as it's not functional. There's been quite a number of cases about protecting dishwasher tablets, but they were held to be not that distinctive because they're all pretty much of a muchness. But we've recently registered a shape mark in the shape of a turtle for dispensing chewing gum, for example. So that, you know, there are options for protecting shapes, and certainly the Coca-Cola bottle is one of them. Again, sounds, Sarah's mentioned, you know, melodies, jingles, that can be registered. Netflix, so yeah, you stole my example there, that's fine. Colours, Cadbury's have purple protected, BP have their green protected. The colour can also be like a position mark, so it can be the Christian Louboutin red sole, that's protected as a trademark, but the position of it is actually on the sole of the shoe. More recently, we're moving into some sort of motion marks where the mark, a mark can have different types of positions and a sequence of movement. Holograms even, smells, smell of Play-Doh, there's a registration for the smell of fresh cut grass for tennis balls, but they're more sort of, they're less common, but quite interesting. And I think in terms of the expansion of non-traditional trademarks, initially the difficulties were ensuring that they had some kind of graphic representation, but that's sort of moved and expanded now. So if a mark can be accepted if it is basically generally accessible in terms of its technology format. So we can file an MP3 file for sound, or MP4 for audio and video. So that really, those multimedia trademarks really bring huge opportunities to businesses in IT, music, film, gaming, and marketing. So it's worth considering, protecting your creations. So just a few points as to why it's worth registering trademarks. As I've mentioned before, it's a statutory monopoly. It's the certificate that you get at the end of the registration process is evidence of title. You don't have to prove that you have a reputation and goodwill, as you would have to if your mark was completely unregistered and you were relying on use built up over time. It's a really valuable commercial asset. You can sell it, you can license it, and in the UK you can file and register a trademark for under £500. So it is easily within the reach of most clients, and certainly worth considering. As I mentioned, renewable indefinitely every 10 years. And it's, once the mark's registered, you can then use the R in circle to deter possible infringers. And once on the register as well, of course, when third parties carry out searches, your mark is always there to be, to identify that you are claiming rights in that particular mark for those particular goods and services. Also gives you a right to sue for trademark infringement, which is quicker, easier, cheaper than any other option in terms of taking action in passing off. There's no need to prove reputation and goodwill, as I mentioned before. So just looking at issues to consider in terms of what could be protected. As I said before, it could be just the word, an image, or a composite of those two things. Also have to consider what goods and services in what countries that you want to apply. It's not possible to add any goods and services to a mark once registered, so that's really important to identify the goods and services of interest, not only on launch, but down the line in terms of future potential expansion of the business. So it's, as long as you have a bona fide intention to use the mark in relation to those goods and services, then we recommend that we have a fairly broad description of the intentions for the business going forward, to ensure that you're protected and don't have to re-register again in future. Also looking at the whole package, really, looking at whether domain names are available, company names, and also social media accounts. Registering a domain or registering a company name is a little bit of a myth, but it doesn't, people tend to think that it gives you some rights, but it doesn't give you any rights at all. It gives you the rights to stop another party from registering that same domain name or the same company name, but you can't use that company name registration or that domain name registration to stop anybody else from using. So in terms of a positive right, only really trademarks can provide that function. But of course, it's very important for your client to ensure that they have all these different rights protected, because if a third party has already taken the particular domain or company name, then it can have quite an impact on the client's business. So just some issues to be aware of when developing new brands. As part of the actual process for your clients, it's useful that you do some background checks, in terms of not only registered rights, but unregistered rights. So it's quite straightforward to do an identical check on the UK IPO register to see if there's any fatal problems that your client might encounter. In terms of unused but unregistered marks, there's obviously no register as such to search, so we have to be reliant upon trusty old Google, carrying out internet searches, and also your client would probably be very familiar with its own business and its own sector, and would be aware of other brands that potentially could cause an issue. It's certainly worth flagging all of these points very early on in the development process to ensure that you don't go too far down the line and become committed to a brand which ultimately might not be feasible and could risk, you know, infringing a third party's rights. These preliminary checks, you know, we recommend that you carry these out, but none of them will remove the need for a proper legal clearance search, and that's hopefully when you might consider coming to us for that. In terms of, you know, being aware of what could be an infringement, the rights on registration of a registered mark essentially means that you can stop a third party from using not only the identical same mark but a similar mark. So if it's confusingly similar, you could be stopped. It could be an infringing act, and not only the goods and services that there's protected under the registration, but there's a penumbra of protection beyond that. So if the goods and services are even similar, not only similar but dissimilar even, you could still be caught. So it's quite a minefield really in terms of ensuring that you don't tread on any third party toes. So please do involve us when you can. Having said that, when we do searches, we can categorize for the client, you know, whether it's a high, medium or low risk issue. We also tend to look at actual use and have quite a pragmatic commercial approach as to whether, you know, there's going to be a real issue commercially. So we can look at whether a mark is actually in use, and if the registration, for example, is in excess of 5 years old, it can be cancelled for non-use. So that could be used in the armoury in defence of any potential infringement action. So yeah, commercially it's useful to look at it in context as well, and you can always come to us for a view if you feel that you've seen something that potentially might be an issue, and we can look at that for you. And finally, you have to bear in mind that marks can also be assigned. So whereas at the moment it might be in the hands of someone fairly innocuous, it could be transferred to one of your client's competitors. So it's useful to know, especially where the current owner is, for example, in liquidation, and its assets are in the process of being sold, and it could end up essentially in the wrong hands. So it's worth doing quite a bit of digging around before a new brand is launched. So I think we're now moving on to the quick poll. So I don't know if
if you go to the next slide, brilliant. Moles, can you put the poll up? 58% haven't been ghosted, but 42% have, which is quite a high trend. So I think what would be great is, Sarah and Lindsey, thank you very much. Should we carry on, and so we'll bring this into the conversation as well. So thank you.
I think it's important to, looking at that poll, that obviously is a prevalent issue, especially in your industry. At the end of the day, you're going to your potential clients and pitching, presenting your works to them, and in that you put a lot of time and work and money into that pitch. And there can be nothing more frustrating than somebody infringing those rights and using it effectively without paying you for it. So I was trying to think of some different examples as to how we could help you with that. Again, some of them are more practical than others, but again, it's worth doing the full suite of options for you. Obviously, when you're going to present anything to a potential client, at certain times we've come across instances where NDAs have been entered into, and so your confidentiality agreements. Sometimes that's part of people's terms and conditions to say that you know, at the end of the day it's clear, but whoever is bringing the work to the table continues to own that even after the event, i.e. after the pitch, for example. But I appreciate sometimes in practice that's not always the best way to start a working relationship, and so sometimes clients can be, or you know, people can be reluctant to push an NDA, should one say, under a potential client's nose. But I suppose it is an option there, and it goes back to making sure that any of your material that you are effectively disclosing, you do mark that correctly as being private and confidential. And I think the key point for me is marking your rights on a PowerPoint presentation or however you present that material, is making sure you have a copyright notice on there. You'll see the little C usually symbol. Again, making sure that's on there, and the name of the company and the year it was created. And also, where possible, putting a watermark over the presentation or any material that you are presenting. This is quite a common theme I'm seeing now in the tabloids. You'll see various different celebrities, for example, with different photographs, and maybe you might have the various different tabloid newspapers, whether that be the Sun or others that are available. You'll see the watermark over those photographs, so it's clear who owns the copyright in that particular material, and also it makes it very difficult for others to copy. And I always say with anything that you are disclosing, only disclose what is absolutely necessary, and making sure that you keep a clear record of what you have disclosed, you know, what material you have, and making it in a list of what has been said, whether that be a minutes after you've had that meeting, being able to just effectively gather together what's been exchanged, what information has been exchanged in that meeting. And again, making sure you have that design trail, as talked about before, can be a useful tool for infringement purposes if you wanted to enforce your rights against a potential third party. At the end of the day, if things don't go to plan, you don't get the work, then there's nothing wrong with sending a polite reminder after the presentation and reminding them that you own the IP rights, you've got something on record there at the end of the day, then making it clear that you are asserting rights over that material that's being presented and put forward. And anything, again, really, that you can try and restrict access to, whether that be, again, I'm talking about PowerPoint presentations, but any kind of material that we could put a password on it or a read only, again, making it clear that as much as you can keep hold of the materials, keep hold of that code, keep hold of everything that you have disclosed, makes it easier for you to keep track of it, and also to try and limit the possibility of somebody, if you like, infringing your rights. And as we've talked about here in the presentation, there's various different rights that can be infringed, and we've talked about them here. And there's the copyright and trademark, obviously the most relatable to you guys, and especially and design protection as well. So again, it's just making it clear. Sometimes it's how far do you want to push the button? How much do you want to work with that potential client again? And have you had a good experience or not? And how much you want to enforce your rights available? Because you can do, there's various different things you can do. And even just like I said before, just sending that reminder, reminding them that you own the rights. It's just putting that marker in the sand to make it clear that you are aware what IP is. And at the end of the day, that you are aware that you own it, i.e. the creator, because they haven't created that material. I was trying to think of any other ways that also that you might be exposed to liability with your own clients as well, because brand owners will now and again take action against infringers, and it's important for you as well as a company to limit your liability with your clients if you're asked to create certain products, especially copycat products that you'll see. Oh, have you seen this design? Have you seen this packaging? Can you make something similar? Again, it's just making it clear that you're trying to limit your exposure to anybody, if you like, coming after you. And having policies in place regarding what materials employees and third parties can use, so making it clear internally as to what exactly your employees have access to as well, so that it is clear as to what the policy is internally about IP rights. And I think that's something that one should always go away and have a review of internally as to how you do, what images and what licenses you may need if you are using different materials out there. As Lindsey's already mentioned about conducting those searches, making sure that you do the adequate searching beforehand as well really does help your liability. So making sure that you've just not, and again, I don't mean to discredit anybody here, but again, making sure you're just trying to do the full searches that you can at your fingertips. So again, that you are limiting your exposure here. And possibly also including what one would call an indemnity clause in your terms and conditions or in a contract to make sure that you're effectively indemnified against any possible IP infringement claims. So effectively, if somebody comes knocking at your door alleging infringement, then you want to make sure that indemnity clause, i.e. you can claim the cost back from your client. And so that's what an indemnity clause does really. It gives you that protection with the liability for costs. In case such allegations were made. And again, making sure your terms and conditions apply and not your clients'. Sometimes this is called the battle of the forms. You may have heard that before. And again, making sure, as I said at the beginning there, you are clear as to what your policy is internally, but also externally, i.e. with your clients, and making sure it is clear in those T's and C's who owns the IP and not the client, if that's not the case. Obviously, if you do a pitch for somebody, you do the work for them, and they've paid you for it, then they may expect at the end to own the IP. But again, it's in your possession to be able to then assign those rights to the clients. That may be part of your package, if you like, that you put forward to your clients. And again, if a claim is to be issued, it's important to remember to establish independent design. So just because, oh, I didn't know about that, or plain ignorant, that's not a defence. So again, it's just need to be able to show that you did go through various different design stages of designing a process or a product, to show that, again, where that inspiration came from and what different stages you went through in order to come up with the final product or final presentation, etc. So having that trail of evidence at the end of the day is really helpful, because, like I say, just pretending, just having ignorance again is not the defence that one would need. So I've tried to just do a whistle-stop tour there, really, of the key rights that we were talking about, which we think would be important in your area. Again, just trying to think about how you limit your exposure with your clients, and also making sure how you assert your rights when you come in to do a pitch or are asked to do work. Again, just putting those few pointers in place, again, just may help you put that marker in the sand as to where IP rights where the IP rights rest. So hopefully that's been useful today. Got any questions? Over to you.
Brilliant, thank you. If you stop sharing your screen, that would be great.
Yeah.
Fantastic, thank you very much. That was really, really informative. So that's really great. There's a couple of questions coming in from chat, so I'm going to bring people in a second. But one of the questions I've got is, you talked about ownership of ideas sits with the author and the first owner. And when agencies are using freelancers, how can they protect themselves, especially when it's examples like coding, when they're potentially using coding from another client that they've worked with and bring it into the code they're working for a current agency or client? How can they protect themselves in that process?
Yeah, I think it's important to understand what you've got with what that freelance contract says, because you're right, at the end of the day, they're not deemed an employee. And so obviously they don't have the employee protection, i.e. it doesn't belong to the company automatically. So you're right, anything that they are doing under that freelance heading is technically owned by them. And so again, it's making sure that obviously you must be paying them to do that work, and so in order to do that there must be some kind of agreement or some kind of communication between the two parties, and making it clear in that particular agreement as to all of the IP is being a condition really of them entering into that work with you. And we've done that a few times with different clients, especially if they've used, I don't know, IT freelancers, like you say, is quite a common occurrence, and making it sure, just a simple paragraph really, just making it clear that they are assigning the rights to you. But again, it's making sure that pen goes on paper to make sure that is assigned back to you.
Brilliant, thank you. Robert McClement, do you want to just come onto the screen and ask your question around the NDA side of things, please? Or has he just disappeared?
Yeah, okay.
Yeah, can hear you, perfect.
Yes, this is something that's been an issue in my mind for a while. Having used NDAs occasionally, they often try to be a catch-all, where it seems that every conversation, every item of information needs to be considered as confidential. And I in the past have tried to reverse the responsibility to the sender of those, asking them to stipulate what it is that's confidential. So the question is a catch-all defensible? And is it reasonable to respond with a, please tell me what it is that you want to keep secret?
No, I think that's a sensible question to ask, because at the end of the day, what is confidential information? You're quite right. Is it the business information? Again, it can be what already is out there in the public domain. If something's already out there in the public domain, it cannot be classed as confidential. And so again, it's making it clear. I think you're quite right there. If we were ever drafting an NDA, it's what is the purpose of this agreement? Why are we entering into this? And that definition is key in anything that you're doing. If you're making it clear, what is the purpose of this agreement? Getting that right is key. And then the second thing that comes along that is defining what exactly is confidential here. What is the confidential information we're talking about here? And making a clear definition of that makes it a lot easier, like you say, if worst case happens, it's clear as to what the purpose was and what exactly was the confidential information. Because you're quite right, just marking everything as confidential information discredits it completely. It doesn't help the situation, and that's not possible, as you quite rightly say.
So one strategy might be to accept a catch-all NDA knowing it won't be defensible.
Well, again, yeah, it is a possibility, I suppose. And you're right, an NDA is only worth as much as you can enforce it. And so if you can't enforce it, then yeah, there's questions of the validity of that agreement. You're quite right.
Okay, thanks very much.
Thank you very much. And Stephen, do you want to come on as well? Because I know this is an issue that actually as a country in China and India are challenging like the global pharmaceuticals about. So if you want to register, be in our country, we've got to take your IP. Stephen, do you want to ask your question as well?
Well, a couple of questions. One is just a general one, which is, IP protection in more sophisticated markets with similar laws is fine, it works well, but in the wild west of China and elsewhere, it seems to be a free-for-all, and ideas and even designs are taken, copied, and it makes it very difficult to actually take on businesses that are on the other side of the world. I know obviously you can register in multiple markets, and that's fine, but realistically, if you are, unless you're Walt Disney or whatever, very difficult to take on these organisations, particularly because they're quite hidden.
Yeah, I mean, certainly in terms of trademarks, I've been working in China for many, many years, and at one time it was really hopeless in terms of, Western brand owners enforcing their rights and that basically having their rights pinched from them by unscrupulous Chinese local companies. But the tide has turned enormously of late, and so in terms of enforcing and protecting trademarks in China and India and other places, it's so much better and a lot fairer. But the question remains, issues of copyright and how those ideas might be taken. It is what you can protect. That's the issue more than the enforcement now is much better. There's ways and means of overcoming issues with third parties taking your rights in these countries through the appeal system in China, for example. But I think
it's getting better, as you say, but nowhere near in an ideal world. But I think as well, a lot of the time, as you've experienced, Lindsey, as have I, it's getting the transliteration as well.
Absolutely.
What we might register of there in English, it's making sure you've got the right transliteration of how it would actually sound over in China, and making sure you've got the protection in that format as well, rather than just the English translation.
A lot of companies have to. Sorry, yeah.
The second question is, creative agencies, in particular PR agencies, end up basically giving away lots of ideas at the pitch stage. And a lot of the things you've been talking about today are great in the sense that, if ideas are stolen, etc., you can demonstrate it, you can demonstrate that, that you had an IP there. And for many years, whenever we used to do pitches, we always used to put a copyright at the bottom. It meant absolutely nothing, but it was just trying to signal to a prospective client, nick this idea at your own peril, sort of thing. Is there a form of words or something we can put into pitch documents that would give some degree of comfort? And I only ask because I think a lot of the stuff you're talking about today is brilliant and it's great for ideas or things that you might want to patent and protect or copyright and protect. But actually, the amount of pitches that agencies do, I mean, we've got PR agencies that do 4 or 5 pitches a week. They'll be presenting 15, 20 ideas. And then the client will go cold on them, and then 3 or 4 months later, they might see one of those ideas pop up, and be very similar to what they presented, or exactly the same. So I just wonder, is there something that we could be putting on our documentation that will give us a degree of comfort?
think there's wording at the end of the day if you're entering into any kind of pitch situation or presenting something across, then you're quite right. It's effectively like a disclaimer, isn't it? At the end of the day, just in a different format. And so you kind of asserting your rights, whether that be at the start of the presentation or at the end, probably at the end, really. And I think it's clear as to, as you're quite right, you're trying to use this as a deterrent. That's what it is. You can't stop someone doing something without, you're trying to deter them from doing it. But if somebody wants to try and steal your work, effectively, if that's what we're talking about here, and they can do it if they've got the material in front of them. But then it's how you go about trying to, number one, try and put them off from doing that. And then secondly, you're quite right, it's then taking action against them if they do that. And whether that be an enforceable term in some kind of contract format, or follow up after the presentations. I think that is something definitely that is worth putting in there, because you're just trying to assert your rights even further and waving your flag, if you like to say, hang on a moment, this is it's a test.
That's the end of the presentation. Sorry about that.
Yeah.
Claire, I'm sorry, I think we deafened you then.
No, I'm sorry about that. But yes, no, I do think that, Stephen, that is something that can be worked into material, definitely. And it's something that, again, it's just putting that message across.
Yeah, and I think in terms of copyright notice, as you say, you've probably been using it for years, but probably a full copyright notice with the date and all rights reserved, and just make it a little bit more legalistic. It's just incremental, isn't it? There's all the little things that you can do.
Yeah.
Hopefully will pull together and have that deterrent effect. But unfortunately, I appreciate that these things are happening quite regularly. It's it's a theft of intellectual capital, really, isn't it? We can only do what we can in terms of what IP rights you can protect.
There are also a couple of places. The IPA and the Alliance of Independent Agencies have a pitch protection form that you can fill in, and actually it's a sort of form of registering for agencies in this pitch process. So we will share up. I'm conscious of time, so I'm going to actually have to end it. But Sarah and Lindsey, thank you very much. What would be great if there are any follow-up questions that come through, I'd love to share them with you and get a response so that we can help. So agencies and members and people to actually just understand and get a bit more sort of response, because there's a lot of information to come, and I think there's more questions that have come through in the chat that we haven't been able to respond to.
If there's anything that comes out of our presentation, we'd like to tell us, could do some further work with you to more tailor to what you want or need. So we're more than happy to come back and work through some questions or.
Brilliant. Well, thank you so much for a really informative session. Lots of tips and lots of information to take on. So we'll be posting the video later today or tomorrow, as I said, on the YouTube page. We'll also be sharing a PDF of the deck, if that's okay. As I said, there is lots more to come. In terms of a few other things I've got to quickly mention. One, thank you. The next BD Club is on the 4th of May. It's a session around CRM and automation, CRM and sort of using CRM more effectively in your new business and marketing approach. That's going to be with Adam at Grey Matters. So there becomes comms coming out around that soon. We still have early bird tickets available for the conference we've got on the Thursday, 22nd of September, which is the inaugural UK Independent Agencies Conference. It's taking place at the Montcalm. And in the next couple of weeks, we're going to be sharing some more comms around speakers and sort of themes. So watch out for the comms coming from that. And in the next month, on the 20th of April, we're going to be hosting a client panel all around the travel sector. So please, again, more details will be coming from that. So again, Sarah, Lindsey, thank you so much for your time today. It's been really informative. If people have questions, please drop me an email and we'll get responses back to you. So thank you very much for your time and see you all soon. Take care. Have a good day.
Bye-bye.
Bye-bye.
Bye-bye.